Morning, Your Honors. The matter before the court this morning is the case entitled State v. Bone, case number 24 AP 076. Representing the appellant, Jamie Bone, is Chloe Vickers. Representing the appellee, the state of Vermont, is Dennis Wigmans.
Thank you very much, and good morning, counsel. We'll hear from counsel for the appellant first. Of course, please identify yourself and your client and then proceed.
Good morning, and may it please the court. My name is.
Good morning. Counsel, can you turn your volume up?
Can you hear me better if I?
Yeah, that.
Okay. My
I'm sorry.
apologies.
Sorry to make you do that, but I think that may be the only way. That's much better.
Okay.
Thanks.
Wonderful. Good morning, and may it please the court. My name is Chloe Vickers, and I represent the appellant, Jamie Bone. Appellant is requesting this court reverse the trial court's denial of her motion to suppress her evidentiary breath test result on two grounds. First, the Derby Barracks knowing utilization of a system that stored recordings for a period of only 58 days is in direct contradiction to the obligations of 23 VSA 1203J and Vermont Rule of Criminal Procedure 16E, thereby warranting the suppression of appellant's evidentiary test result. Second, appellant produced sufficient evidence to demonstrate that footage of her processing was taken but not preserved, also in violation of 23 VSA 1203J and Vermont Rule of Criminal Procedure 16E, which again warrants the suppression of appellant's evidentiary test result. As to the first point, it is to the detriment of Vermont criminal defendants that the Derby Barracks knowingly utilized a system that stored recordings for a period of only 58 days. Utilizing such a system is especially concerning when one remembers that the Derby Barracks previously utilized a system that stored recordings for an indefinite period of time. The directives of 23 VSA 1203J and Vermont Rule of Criminal Procedure 16E are clear in that law enforcement is obligated to preserve footage until 90 days have passed from final judgment or 90 days have passed since the footage was created and no criminal or civil case was filed. Here, the former applies as appellant was arraigned 30 days after the date of her arrest. The burden to utilize a statutory and rule-compliant system rests squarely on the Derby Barracks' shoulders, and their failure to do so warrants the relief appellant seeks. Within its reply brief, appellee misrepresented a Derby Barracks quote-unquote policy. Appellee stated incorrectly that the Derby Barracks public safety barracks clerk, Gregory Marsh, testified during his deposition that there is a policy that a processing trooper create a copy of a processing video on the day that a processing occurs and provide the copy to him being Mr. Marsh. Within his deposition, Mr. Marsh never used the term policy to describe this instruction or guidance that has been given to troopers at the Derby Barracks. Even if there was an official policy dictating that the investigating trooper is responsible for preserving recorded footage, such a policy does not absolve the Derby Barracks, Vermont State Police, or the Department of Public Safety of their responsibility to preserve footage and utilize systems that comply with mandated requirements. This is a systematic and avoidable failure that warrants the recourse appellant seeks. As to the second point, appellant produced sufficient evidence to the trial court to demonstrate that her processing was recorded, or at the very least produced sufficient evidence that it was more likely than not that her processing was recorded. The only evidence that would definitively prove appellant's DUI processing was recorded is the recording itself. However, due to a combination of factors, none of which can be attributed to appellant, the processing footage was not preserved. Moreover, law enforcement should not be permitted to choose to implement a system that deletes recordings automatically prior to the statutory and rule timeframes, only to turn around and utilize that non-compliant system to their benefit by claiming a defendant cannot prove a recording existed. Again, the facts of the underlying case warrants the recourse appellant seeks. An appellant's assertion that her processing was recorded but not preserved is supported by both Trooper Brian Connor and
You have
Gregory.
1 minute. You have about 1 minute, counsel.
by Trooper Brian Connor and Gregory Marsh's depositions. And if there are no questions, I would ask to reserve the remainder of my time.
Okay, thank you very much. We'll hear from counsel for the appellee. Please identify yourself and your client and then proceed.
Thank you, Your Honor. My name is Dennis Wigmans. My client is the state of Vermont.
Thank you.
In our brief, we did neglect to actually include an important fact in this case, and that's at PC 50 in the printed case, where the deponent, Mr. Marsh, testified that about a year prior to the deposition, the recording device was changed from that which recorded for an indefinite or maintained the recordings for an indefinite period of time to one that only maintained the recordings for up to 58 days. It's important to note that the appellant was arrested 15 months prior to this deposition. And so we don't really know which system was in place at the time, whether or not it was the one that preserved indefinitely or the one that only preserved for 58 days. Now, we argued in our brief that not a proper foundation was not laid to show that Trooper Connor had uniformly and semi-automatically recorded processing. That's the requirement in order to show habit. But just assuming that it was his habit to record, you have to also assume that the system was operational. And we heard from both deponents that at times their system did not, in fact, work. So if the system was operational, then if you assume that it was Connor's habit, it was recorded, he preserved it to disk, but the disk was lost. It was preserved on a disk. No one could find that disk. That's if he followed the habit. But by his own admission, he often or at times did not actually follow the instructions. He had forgotten to push record, for example. He had forgotten to make recordings. Under those circumstances, a disk wasn't made. And so there wasn't anything to preserve. There wasn't anything to share. And under Dimick, or as Dimick notes, there's no recording, no statute requiring a recording be made. If it wasn't operational, same result. No requirement under any statute that a recording actually be made. If it was operational and it was the old system, again, if he followed his habit, then preservation occurred. He would have recorded it to a disk. We're just dealing with lost evidence, in which case you apply the Bailey factors. Assuming that there's negligence, defense has to show that there was a likelihood that there was exculpatory evidence therein, and has to show that it was prejudicial to the defense. No such allegations exist here. If he didn't follow it, then again, no statutory requirement. Now, if it's the new system, same result. If he followed his habit, it would have been preserved to disk, and the disk doesn't exist, can't find it, in which case there is no statutory, in which case it's negligence. And again, you apply the Bailey factors. If not recorded, then there's no statutory requirement that one be recorded. It wasn't unreasonable, given all of these unresolved variables. It wasn't unreasonable for the trial court to find that a recording just wasn't made in this case. In addition, we argue that, oftentimes where you have so many unknown variables, the simplest explanation is the typical outcome. That's probably what happened. In these circumstances, the court was faced with so many unknown variables. There was also no bad faith here. Under the old system, as the appellant notes, those recordings were preserved forever. We just don't know when Mr. Marsh checked. We know that it was checked in February, the following February, which is well beyond the 90-day statutory limit. Under the new system, either no recording was made, or the system wasn't operational, or a recording was made and a copy was made, in which case we're once again faced with lost evidence and applying the Bailey factors, or a copy wasn't made, in which case Trooper Connor didn't follow his habit, and also didn't follow the advice. We called it a policy because it was communicated to the troopers repeatedly. It seems that it was a barracks-wide policy that once a processing occurs, trooper makes the recording, and then that recording is shared with Mr. Marsh for disclosure. If he didn't do so, again, we're looking at the Bailey factors because that was mere negligence. There's no evidence presented that the state police implemented this system in order to circumvent discovery.
You have about 1 minute left, counsel.
Thank you. And just 3 clarifying points, if I may. First,
Oh, hang on. Mr. Appelli, were you finished? Perhaps I missed it.
I was told I was out of time.
Is that right, Mr. Bailiff?
Yes, Appelli had no time remaining.
All right, I get it. I missed the warning. So how much time does the appellant have, please?
Appellant has 47 seconds remaining.
All right, now go ahead, please, counsel.
thank you. I would just like to make 3 quick clarifying points. During Gregory Marsh's deposition and located on PC 51, he did clarify that in May 2021, when appellant's processing occurred, the 58-day time frame was in place and being utilized by the Derby Barracks. Trooper Connor testified that it was likely he recorded appellant's processing. And my last clarifying point is that appellant requested her footage 33 days after her stopping processing, but did not receive any response from the Derby Barracks until August 2nd, 2021, which was 78 days after the footage's creation and 20 days after expiration due to this system. Thank you.
Okay,